going to take some time now for some key takeaways from our panel members. And we're going to do this in the order that the presentations were made. So I would like to start with Mark Deming. Mark, what are some key takeaways you have for our attendees today?
Sure, thank you. The primary takeaway, I think, with respect to the IPR discussion that I presented earlier today is the fact that I don't think the success rate in patent office proceedings is demonstrably higher than you would expect in a district court litigation, which is a little bit unusual compared to patent litigation and IPR proceedings in other areas of technology. And from what we're seeing in terms of trends and filings year to year, it seems like that will hold true going forward, absent some sort of disruptive decision, by the Supreme Court in the oil states case. And then with respect to venue, I think what we're going to see is that venue is going to become a more important factor going forward. It may be more likely to have parallel litigations going on in different courts. We may see an uptick in the use of multi-district litigation. But ultimately, different courts have different tendencies. We're going to see different time to trial, local rules, et cetera, that are going to input some variability into how Hatch-Waxman cases normally proceed that we may not have seen in recent years. Thank you.
And thank you, Mark Deming. Martin Pavane, would you care to take a minute, maybe 90 seconds, for some key takeaways?
Sure. I addressed quite a disparate group of cases, so I guess there are different takeaways in different cases. But I think for the Eli Lilly case, a takeaway would be that regardless of which side you're on in one of these inducement cases, you have to look at the labeling instructions very carefully to see if there's any language in there that is problematic in terms of an inducement claim, and sometimes even go outside the labeling instructions, as occurred here with respect to physicians' guidelines that were published independent of the labeling instructions and distributed to physicians. In the medicines case, I think the key takeaway there is the fact that you may have an opportunity in some circumstances to develop a very narrow claim construction depending upon how much disclosure there is in a particular case to support the claim. And, of course, in that case, the prior art also impacted the proper wording or proper scope that could be given to the claim. So that's important to evaluate. In the Shire v. Watson case, it's an interesting case from the point of view of just understanding under what circumstances you can interpret a Marcouche group claim to be closed and therefore excluding other elements as to whether they are relevant or not related to the invention at issue. And in the Mylan case, I thought that was interesting because it specifically is a guidance from the Federal Circuit that made it clear that the function-aware result test or for a doctrine of equivalence is not always applicable when you're dealing with chemical inventions. And then, of course, the Amgen-Sanofi case is significant because it's, I think, the first case I'm aware of where the Federal Circuit said that in evaluating written description and enablement for genus-type claims, it's appropriate to look at evidence developed after the priority date of the patent.
And thank you for that, Martin Pavane. Finally, Joseph Reisman, would you care to take a minute to maybe 90 seconds, some key takeaways on your presentation?
Sure. As I mentioned during the talk, there's a real reason to follow what's happening with inherency in the context of obviousness, but the larger trend that we're seeing, particularly with the Merck v. Hospira case and the Bayer v. Watson case, is a slow resolution of the role of objective indicia in an obviousness analysis. Patentees have to make sure that they're not saving their best arguments and their best evidence for objective indicia, but try to wrap that type of evidence into the first 3 gram factors. So a reasonable expectation of success is not going to be compartmentalized along with commercial success, perhaps. And making your argument in the so-called prima facie case of obviousness may be a better way to go, given some of the trends recently at the Federal Circuit.